Good morning, everyone. A dictionary of the sovereign people. The law, the people, their sovereignty, their rights, their land, their government, and its property. My people are destroyed for lack of knowledge, because thou hast refused knowledge. I will also refuse thee that thou shalt be no priest to me, and seeing thou hast forgotten the law of thy God, I will also forget thy children. Geneva, 1599. A corrupt system finds its security in the ignorance of the people. Publius. A treaty on and repository for the principles of the natural law taken from the Constitution and laws of the United States of America, and their specific application to the people as citizens of the several states of this American Union with reference to the common and natural law of America and its European founders, by Publius. In the Common Law Republic of California, established 1849, created according to prerogative right, the American common law and sovereign duty for the education of the posterity of the founding fathers, Federalists, nunc pro tunc, from the year 1776. Prelude. This writing is in a dictionary format and is in the best King's English, and is based on the principles and wording taken from Blackstone's Commentaries, Chapter 7, The King's Prerogatives, 1753, The Federalist Papers, 1788, Library of Congress, as well as many never overturned Supreme Court rulings, such as Chisholm v. Georgia, Lansing v. Smith, Dred Scott v. Sanford, Hennessy v. Richardson. Also, Noah Webster's Dictionary of the English Language, 1828, Bouvier's Law Dictionary, 1840, 56, and 1914, and the many other sources of our liberties, to name a few. Intent. This is not an attempt at ethnic cleansing and must not be viewed as racially motivated, but is a path for all people to see the truth within themselves. That being said, the purpose and intent of this dictionary is to perpetuate the law of God on earth in the United States of America, and by this principle to expose and correct the many errors, deviations from the truth that have been committed by those so-called educated individuals, and their misuse of words, their confounded definitions, their fraudulent applications, and the erroneous capitalization of most of the technical words that are now compiled in the many volumes of legal and lawful writings that fill the law libraries of each and every county in these federal states. The words that I shall identify have now become a source of deception and fraudulent guide for the average person, leading to the total ignorance of the people. European descendants of these United States in America, and an unlimited source of dollars for a constitutionally prohibited foreign central bank. Rules of engagement and their application. This writing is not laid out in alphabetical order, but instead is in consequence of the evolution of our federal system in time by chronological date from at least Magna Carta 1215, an act of defiance by Europeans in Europe, through the Revolution 1776, revolt of the descendants of the Europeans in America, up to its impending demise. I must first set the rules that must be adhered to in order that the reader might catch a clear and true understanding of the proper use, meaning, and application of each word as they are confined to our federal system in the United States of America, and their applicability and intent when applied to the people as defined herein. Rule number 1. Noah Webster authored and compiled the best known available English language dictionary defining the words of the English language in a very broad general sense, from at least Magna Carta 1215 to 1828. Although not created in the best King's English, it is still in print in the United States of America and is preceded only by the Federalist Papers and the Supreme Court decisions on each technical subject. Note that whether by mistake, ignorance, or criminal intent, none of the case law or reprints are done in the best King's English. For the best example of the King's English, see the original script Constitution of the United States of America, 1788, or see Public Law 91-589, 92 Congress, Second Session, Senate Document number 92-82, U.S. Printing Office Stock Number, dated 1972, for a literal print copy of the original script in type. Rule number 2. At the Revolution, 1776, each one of the people who was a subject of the crown in Europe became by natural law a sovereign and citizen of that state. In America, in consequence of his or her domain domicile. Rule number 3. At the Revolution, the 13 feudal colonies in America held by the Crown of Europe became by force of law alloidal, independent, sovereign states. Rule number 4. At the Revolution, the total sovereignty impregnated in the person of the Crown of Europe over the 13 feudal colonies in America was transferred and granted by force of natural law into the citizens of the state and their posterity, who in that moment of revolt became a law unto themselves, unique as to all the other sovereign nations in the world. Rule number 5. At the Revolution, the private prerogatives of the crowns of Europe and all the political power exercised by them over the 13 feudal colonies and their subjects evolved by natural law into citizens of the state. Rule number 6. At the Revolution, all the crown land of the original 13 colonies in America became independent sovereign states and the exclusive alloidal property of the new sovereign people, now equal to all other sovereign nations of the world and all future land, claimed or purchased under the authority of these people, after qualifying under Article 4 with a republican form of government and becoming a state on an equal footing with the original 13 states of the American Union, were from that moment and forever subject to the private or alloidal domain claims when made by one of the people, descendants of Europeans, and a citizen of that state as one of the several states of the American Union. Rule number 7. The Federalist Papers are the final word on the interpretation, intent, and application of the original Constitution. And when a question arises about the strict meaning of any word in it or the law applicable to it, reference must be made to rule number 1, Publius. Chapter 1, the law. This writing is based on the principles of the American Common Law and Truth, July 4, 1776. When the founding fathers revolted and shook off the fears of self-responsibility and the chains of subjugation on the continent of America, they planted the seed of individual sovereign liberty here. Once that seed was planted, the fruit of that seed produced a federal union of individual sovereigns. That federal union was a people descended from the European bloodline, governed by what they called the common law of England, that was birthed at the signing of the Magna Carta. That seed took 561 years to grow into a sovereignty of, by, and for the white European people. This common law is a creation of God that operates equally upon all of God's creatures. It certainly follows that the common law of retribution, cause and effect, applies to everyone. The following quotes are just a few examples. 1. You treat your fellow man and woman as you want them to treat you. 2. You do unto others as you want them to do unto you. 3. What you do to the least of mine, you do to me. 4. You reap what you sow, an eye for an eye. 5. A pound of flesh for a pound of flesh. But vengeance is in the hand of God. These are just a few of the common laws that the founding fathers used in the creation of this nation. If you are blessed with the gift of being a wise counsel and godlike example for people, and you use this gift for self-enrichment, personal power, to inflict your will over other people, you are violating one or more of the common laws and will reap the consequences of God's American common law. This common law, as distinguished from statutory, equitable, or civil law, is the foundation upon which the state of California was founded and is the law in all the courts of this state. See California Statute 95, April 13, 1850. Report on Civil and Common Law, establishing in place the civil law, the American common law, at page 604, and confirmed in California Code, section 22.2, 1986, and Black's Fifth Law Dictionary, 1979, page 251, and Emma Rojo v. Kliger, and Fenn v. Home. It's the nature of words to cause the human mind to identify with pictures. It has been said that one picture is worth 1,000 words. Different strict words in their acceptation are generally used to create different strict pictures. Therefore, when two different words are used in their strict meaning to identify two strictly different pictures, the mind automatically sees two strictly different pictures. This principle is sound and maintains the picture of truth, as was in the minds of the founding fathers. When they used the word citizen, it was associated with only one of the 13 states, not all of the 13 states. They were citizens of a state, not a citizen of the United States. But what if, during a long chain of writings, someone vested with authority were to replace the proper noun word citizen as it was capitalized and written in the original text of the script Constitution of the United States of America with the common noun word citizen as used throughout the rest of the world? The original proper noun citizen is the first principle of our American common law that describes that specific member of the specific class of uncommon European descended people known individually as a citizen of a state of the collective United States of America, as written in Article 4, Section 2, Original Constitution of the United States of America, 1788. The citizens of each state shall be entitled to all the privileges and immunities as citizens in the several states. Thus was the case by Thomas Jefferson in the first naturalization law, 1790. Not only is the word citizen not properly capitalized, but also makes reference to the United States, a municipal corporation, D.C., not yet created until 1795. If you place the word white next to one of the qualifications for citizenship, there is now a very distinct difference between this citizen and all the other lowercase c citizens before the Revolution of 1776. They are what the Supreme Court has generally called the sovereign people, synonymous with we the people and citizens of the state. This application of the word citizen, properly capitalized, is now an exclusive picture of a white citizen of European descent domiciled in one of the several federal states in America, and is now a proper noun and properly capitalized when and whenever the government needs to identify this exclusive sovereign status. Refer to the case of United Mine Workers 330 U.S. 258 footnote 2324 1947. No other word like person, individual, resident, taxpayer can be used in any law to have any lawful application to the private person or property of a white citizen of the state. But through the many erroneous acts, legislative, executive, and judicial, this proper noun citizen has regressed back in time when it described only a subject of the crown. Thus begins the creation and infusion of a negative power system. Such a system, like a democracy, is now used by the traitorous, treasonous elected trustees to empower themselves through the influx of a majority of aliens and their want for a free lunch. Thus, the extermination of the white citizen of the state replaced by alien denizens of the municipal corporation of the District of Columbia, aka the United States. And this new age of enlightened ignorance is found a growing element called by the government as the sovereign people. This new class of people is hard on the minds of the present system. The system is trying to discover a cure for this newfound ailment that now threatens its democratic communist monarchy. But it will be discovered, like the revolution, that tyranny at any level or degree will at some point be exterminated, and the people will reappear as before and start anew as the posterity of we the people in this republican form of government. These false tools, as used by the confounded teachings of the present democratic government controlled education system, teaches that the use of common words that have uncommon meanings in our federal system. This creates a false picture. As previously explained, when the word citizen is used in the Constitution with a capital C, it is describing a white European sovereign citizen of one of the several states in his sovereign person with unalienable rights. On the other hand, when the word citizen, lowercase, it describes a common person, although appearing to have an elevated status, but is now nothing more than a subject of the District of Columbia, not a state, having only civil rights and bank chattel. This is for the strict benefit of the civil code system, not the sovereign people. The posterity and their senses have not yet properly developed according to God's law, but have instead become jaded and destructive to themselves and their neighbors. The present code has hidden the access to the strict pictures of the law, blinding the posterity from discerning the difference between right and wrong or unalienable secured rights as opposed to civil guaranteed rights. The word law, hereafter defined, emanates from God and can be seen through man's actions, either through his heart or his mind. When his heart is right, his actions are seen as godlike, and the effects are of love or simply positive. When the law of God is diffused through his mind by ego, lust, anger, greed, attachment, or vanity, his heart becomes grieved, and the effects are simply negative. It is the sovereign nature and power of God to instruct man through the operation of the law of cause and effect. This law is the grand design and the rule from God, showing exactly how man and woman are to listen, not through the senses, but from inside their person, and to therein discover the domicile of him of the law of God, and learn to act from the word of God, or to gain enlightenment, or suffer, as the case may be, the consequences for not hearing. The word legal is a creation of man and is not synonymous or equal to the word lawful. It is simply a jaded or confounded picture of the law. It is used to convince man to follow a code or man's rules that use words taught by the system that are of common use, but that define acts or things that subject the people by their ignorance to a regulatable code, which when not compiled with, when not complied with, causes fines, fees, and criminal commercial punishment. The code regulations are used to identify strict acts of a commercial nature, but that also identify the prerogative unalienable rights of the posterity. These catchwords are in every code, state and federal. When man's rule as written does not acknowledge God's law or fails to identify the path of God's law, it is a wrong or simply an incomplete legal rule. The rules of man, with the exception of the Constitution 1788, have always been identified as a code, but there is a lawful statute upon the books of the California Republic that was later codified as the California Motor Vehicle Code that not only identifies the legal licensable activity and the license fee associated therewith, but this statute also shows and distinguishes that legal licensable commercial activity from the constitutionally secured, lawfully exempted prerogative, unalienable right of liberty secured to the posterity under God's law, and the revolt of 1776. The following is an actual quote taken from the statute, but unfortunately, like most other statutes, fails to cite its specific constitutional authority. Chapter 412, 46, Session 833. An act to impose a license fee for the transportation of persons or property for hire or compensation upon public streets, roads, and highways in the state of California by motor vehicles, to provide for certain exemptions, to provide for the enforcement of the provisions hereof, and for the disposition of the amounts collected on account of such licenses, to make an appropriation for the purpose of this act, and to repeal all acts or parts of acts in conflict herewith. The people of the state of California do enact as follows. Section 1. The words and phrases used in this act shall, for the purpose of this act, the words and phrases used in this act shall, for the purpose of this act, unless the same, by contrary to or inconsistent with the context, be construed as follows. The word operator shall include all persons, firms, associations, and corporations who operate motor vehicles upon any public highway in this state and thereby engage in the transportation of persons or property for hire or compensation, but shall not include any person, firm, association, or corporation who solely transports by motor vehicle persons to and from or to and from attendance upon any public school, who solely transports his or its own property or employees or both, and who transports no persons or property for hire or compensation, but all persons operating freight-carrying vehicles so exempted shall be required to obtain from the State Board of Equalization and to display exempt emblems in the manner herein provided. This act further states that the exempt plate shall be obtained from the California Board of Equalization without fee or charge. To see the intent of the authors of the phrase motor vehicle and used for commercial purposes, they are strictly defined in the United States Criminal Code, Title 18, Chapter 2, Aircraft and Motor Vehicles, Section 31 as definitions and states as follows. A. Definitions. In this chapter, the following definitions apply. 1. Aircraft. 6. Motor vehicle. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation of passengers and property or cargo. 10. Used for commercial purposes. The term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other compensation, or directly or indirectly in connection with any business or other undertaking intended for profit. This is a commercial code applicable to anything or anyone that chooses to violate the American common law. In place of the regulatable, taxable, licensable, finable, fee-laden, man-made codes and regulations for affecting or contracting with the public at large. Law equals God, equals the people, posterity, equals unalienable rights, equals sovereignty of the white citizen of the state, equals the American common law, equals the Constitution, equals trust, equals government trustees, equals statutes under the law to protect and defend the sovereignty, their prerogative rights, and the private property of the people and their posterity. Following an act of the legislature, once that authority from the Constitution is cited, the statute under the law is created and a code may follow. This code is then legal by way of the execution of police powers, which mandates license, equals permission to engage the public for profit or gain, equals commerce affecting the public, equals codes, rules, regulations, equals contract with the public, equals violations of the public trust and or the commercial and criminal codes, rules, regulations, equals commercial, criminal, which are all legal commercial crimes. This system derives its security from the ignorance of the posterity, and each of them, Publius. Man, out of ignorance and fear, has chosen to be trapped under a legal system distinguished from the American common law, created for the strict protection of his unalienable rights. This protection is found in the enactment and enforcement by the police powers, under authority of the commercial code, rules, and regulations that apply specifically to the specific activities of an artificial nature that is commercial. When a person engages the public in a licensable, taxable, profitable act that the founding fathers placed under the strict guidance and control of those most learned of the people by and through the constitutionally created trustees of the American common law government. The posterity is left to discover the key to the exit of this code system. Law. According to Noah Webster, 1828 American Dictionary of the English Language, hereafter referenced as NW 28, there are at least 30 different notations on law, none of which specifically identified the law emanating from the creation of the United States of America by its European descended people. This law could be and should be the law of God on earth. The closest Noah Webster comes to this law is called, in number 8, moral law, a law which prescribes to men their religious and social duties. In other words, their duties to God and each other, delivered to Moses on Mount Sinai. Exodus, at the Revolution of 1776, the European people of the United States in America became sovereign under God, and by this act became a law unto themselves. This law is common to the people on earth, not just Europeans, but to all classes and faiths, and therefore falls under the definition of the common law of nature. The law of nature is the righteous law which God, the sovereign of the universe, has prescribed to all men and women, not by any formal promulgation, but by the internal dictate of consequence alone. It is discovered by each of us from its effects upon ourselves and that of other humans and nature, resulting from our individual and or collective acts, culminating from such causes which are the plague and nature of man and woman on earth. The righteous law is not amendable or subject to any complaint or dictate of man. It treats of the divine rights of the people as well as that of kings. It works both ways equally, so that neither can escape the effects of a trespass upon the other's rights. The negative cause creates a negative consequence. To have to write the law upon the books and use this as a guide to keep society right with the moral standards of life is a futile attempt to halt the disorder in a society. As the human race enters upon its decline in civilized standards, there is and was a transfer of the righteous law from man to constitutions, enacted statutes, and civil and criminal codes. In other words, from moral standards deeply embedded in the inner consciousness of the people to the laws and rules written in books. When the time came that the law of righteousness was no longer in the hearts of the people, but in their enacted books, then the decline of the union of righteous men began. Consequently, it comprehends all the duties and payments which man, by his ignorance, owes either to God, to himself, or to his neighbors, such as reverence to God, temperance, honor our parents, benevolence to all, a strict adherence to our engagements, gratitude, punctuality, patience, and a strict discipline to the act of unconditional love. Publius. The Constitution of the United States of America, 1788, is the rule of law of the white European people and was an attempt to create a higher physical environment far removed from the European monarchies of chaos and subjugation, for the express purpose to help awaken this moral, righteous law in the hearts of its people and an example to the world. The several states of America is the perpetual bloodline of a group of individual federal sovereign citizens of European descent, united to form the repository for the key to the door of the laws of enlightenment on this physical world. Although founded out of the revolt to secure the principles of liberty, this is the one nation under God on earth, where a common man or woman, if she knows the rules of law, can exercise that God-given unalienable right to consciously take part in the creation of her own destiny. This is a prelude to a higher state of consciousness, as well as partaking of the privilege of the sovereignty secured by God to the people in this nation. Publius. Refer to Article 1, Section 10 of Amendment Constitution of the United States of America, 1791. The United States of America, in the best King's English from the Revolution of 1776 up to and including the ratification of the Constitution on June 21st, 1788, and just prior to the establishment of the seat of national and federal jurisdiction on July 16th, 1790, known as the District of Columbia, a municipal corporation. The phrase United States had but one and only one meaning, that being, it described the 13 independent sovereign states united under God by the mutual collection prerogative act of the European male sovereign state militia citizens, the people in their person as individual sovereigns, united for their mutual benefit and the ultimate protection and security extending over all the federal states for themselves and their posterity. These people were all of European descent. Publius. See the U.S. Supreme Court's confirmation in Dred Scott v. Sanford, 60 U.S. 393, 1858. On June 21st, 1788, following a great deal of debate and the publishing of the Federalist Papers, the ninth state of New Hampshire caused the divinely inspired Constitution of the United States of America, the People's Law, to become the federal law of the land in every republic state of the Union, including a not yet established municipal corporation called Washington, D.C. At least two major unforeseen flaws, not errors, remain in that document. The first flaw, unforeseen by the founders, has allowed the Constitution to be altered in such a way as to open the gate of freedom to a constitutionally prohibited enemy, the bank, well known to the founding fathers, and to nullify the value of the people's labor. The lock that secured this gate was Article 1, Section 10, Clause 1. No state shall make anything but gold and silver coin a tender in payment of debts. The hole left unplugged was a yet-to-be-formed municipal corporation called the District of Columbia. Although D.C. maintained a gold and silver standard, it nullified its example in 1871 after a civil war by way of 41st Congress, Session 3, Chapter 62, Section 18, as there was no constitutional prohibition against banking or the circulation of bank paper in D.C. The bank faction, through Hamilton, soon implanted its foreign jurisdiction within this nation. See McCullough v. Maryland, 17 U.S. 316, 1819. And by the Federal Reserve Act of 1913, and the ignorance of Ron Paul in a Senate hearing with Bernanke, this fraud has extended its infectious tentacles through fraudulent contacts, void licensing, and foreign commercial powers over the posterity and throughout the several sovereign states of this American Union. This foreign enemy bank, by way of its morally degenerated business practices of mortgaging the people, HJR 192, I would think that's House Joint Resolution 192, and circulating its non-redeemable paper as legal tender, has assumed, through the greed and ignorance of the posterity, total control over the posterity, their private property, their gold and silver coin, their labor, and the total alienation of their sovereignty and their federal and state constitutions. But it's fixable. The second and most damaging flaw, not error, was the failure of Madison and the following Supreme Courts to emphatically and in strict words explain and show in plain English the true intent and true meaning and true definition of the word amendment as it was written by the Founding Fathers in Article 5 of the Constitution. First, I must quote Madison from the Federalist Papers, in which he states, 1. To provide for amendments to be ratified by 3/4 of the states under 2 exceptions only, that useful alterations will be suggested by experience, could not but be foreseen. It was requisite, therefore, that a mode for introducing them should be provided. The mode preferred by the convention seems to be stamped with every mark of propriety. It guards equally against that extreme facility which would render the Constitution too mutable, and that extreme difficulty which might perpetuate its discovered faults. It moreover equally enables the general and the state governments to originate the amendments of errors as they may be pointed out by the experience on the one side or on the other. Madison, number 43, Federalist Papers, page 278. So what error has been pointed out? Amendment. Noah Webster, to correct. It's a, what is it, verb? To correct. To rectify by expunging a mistake, as to amend a law. It differs from improve in this, that to amend implies something previously wrong. To improve does not. 3. In law, the correction of an error in a writ or process. If the word amendments was all that Madison intended, he would not have added the word error in the Federalist Papers. Error, noun, a wandering or deviation from the truth. Noah Webster. A writ of error is a writ of right. Bouvier's 1914, Volume 1, page 210. This writ was displaced in our law by 68 Congress Session 2, Chapter 229, Section 237 and 238. Also see 359 U.S. 437. Was the Constitution or any part of it a lie? I think absolutely not. Publius. The Revolution of 1776 and many of the Supreme Court's rulings deciding errors, such as in Chisholm v. Georgia, 2 Dall 419, 1793, emphatically explains the true principles of the people and their relationship to their sovereignty. This case was so powerful that it caused those factions, Democrats, Republicans, Socialists, who were already busy with deceptive work in each state, to bring about the so-called 11th Amendment. This so-called amendment, in fact of law, violated the intent of the Federalist founders and took away a prerogative due process right of all the citizens in the several states and their posterity. This right was to sue another state in the one and only court created by the hand of the people in Article 3 of the Constitution, which is the Supreme Court, and its sovereign by its nature and its delegated right of error. Writ of error. When the Constitution, the law of the people, is in jeopardy. This court, by the intent and nature of its creator, the people, owes its highest duty and allegiance to the people. This duty is to discover and expose all erroneous acts committed by the legislative, executive, and judicial branches that, by their intent, are in direct conflict with the Constitution and inconsistent with the principal security of the sovereignty of the people who created it. And during or after the discovery of such errors, this court, by its sovereign authority, is emphatically and without question immune and exempt from any reprisal in refusing to exercise their power to enforce those discovered errors. These discovered errors of law are void in their inception, and this court is not bound by or held to any rule or code of any subsequent or following act of the legislature or executive or judicial branch under the discovered error. Mugler v. Kansas, 1887. But the Supreme Court is and should be, by the law of its allegiance and creation, extremely prejudiced to the law of its creation and the will and intent of the people who created it, for the express purpose of protecting and defending the unalienable rights of the people and their posterity against all acts of their representatives, and as stated by the Chisholm Court, while dealing with the rights of contract between the highest sovereign statuses of this nation, and by the ruling in the Chisholm case, the due process right of a sovereign citizen of one state to bring an original action of a sumpsit in this Supreme Court against a union of fellow sovereigns incorporated as another state. See the original Article 3 US Constitution 1788 Section 2. And like the so-called 11th Amendment, if you wish to discover or presume to find the alleged errors cited by their originators authenticating the lawful nature of the following so-called amendments, 11 through whatever, happy hunting, because there were nor are there any to be found. And each and every so-called amendment that has now been crammed down the throats of the posterity after the original Bill of Rights in 1791 is a void amendment for failing to show the exact error, deviation from the truth in the original Constitution, and treasonous upon the posterity of our sovereignty. There was never an error discovered, shown, or stated in Article 3 by the originating proponents or creators of the 11th so-called amendment, nor can there be any found today. It was the default ruling of the Chisholm Court and their blistering opinion against the state of Georgia that caused the void enactment of the 11th so-called amendment. It was the overpowering reality of the sovereignty and power of the people addressed by the Chisholm Court, enforcing the absolute sovereign power of the white people as an individual private citizen of a state to win an action in equity in the Supreme Court over another state. That brought about the creation of the void 11th so-called amendment. Although not blatantly showing and describing this fact of law, the Chisholm Court also showed that Congress is not without error. See Chisholm at page 420, lines 22 and 23, where Congress erroneously inserts the words, but not exclusive, with which words are not found in the wording of Article 3. Again, error, a wandering or deviation from the truth. Noah Webster. The following questions and answers are based on the principles of law as applied to the white European sovereigns of this nation. The questions that never came before the court in any case, especially Hollingsworth v. Georgia 3 Dol 1798, was: question 1. Did the Supreme Court in Chisholm 2 Dol 1793 err in its ruling against Georgia? Answer. The principle of this case is simply stated by the following Supreme Court ruling in Miranda v. Arizona, 1965. Where rights secured by the Constitution are involved, there can be no rulemaking of legislation that would abrogate them. Enter the void 11th Amendment error. Question 2. Was it the intent of the founders to vest the highest sovereignty of this federal union nation in a government over the people? Answer. The revolution and complete separation of we the people from all the other powers on this earth secured the sovereignty of the people, which would be more than enough evidence to show anyone of average intelligence the force of natural law and the true intent of the founding fathers enforcing it. The Federalist Papers, followed by the Chisholm case, would be a good starting point for your enlightenment. The people surrender nothing. Question 3. Is a state of this union higher in its sovereignty than the posterity of the people of the founding fathers who created it? Answer. By the revolution in 1776, we the people established the sovereignty of the people, the states, and the Union of States. And by the Federalists' own words, the people surrender nothing. Federalist 84, page 513. The only power enforceable over we the people was and is God. Question 4. Could there be found a lawful code, rule, order, treaty, or judicial decision enacted by the legislative, executive, or judicial branch of our government, either state or federal, purporting or vested it or any of them with the power to overturn and or nullify a constitutional principle established by the revolution that secured the unalienable rights of the life, the liberty, and the pursuit of happiness to we the white people and their posterity? Answer. If such a power by code, rule, statute, treaty, or executive order, or otherwise purporting to be such a law could be found, those creating it, those enforcing it, and those executing it upon the unalienable rights of we the white people or any of us or our posterity would be guilty of treason. The term treason appears only once in the Constitution in Article 3, Section 3, wherein they state treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. The prelude to this article is found in Federalist number 69. Hamilton states, all conspiracies and plots against the government which have not been matured into actual treason may be screened from punishment of every kind by the interposition of the prerogative of pardoning. So what conspiracy or plot has matured into actual treason? And who are the conspirators adhering to our enemies? As the plot to convert the people's gold into non-redeemable legal tender bank paper and the people to remain as crown subjects was the initial cause of the Revolution 1776. All of those who remained in the states after the revolt or followed the criminal nature of banking and again began in Maryland by Hamilton in the 1790s, unless they survived the Federal Reserve Act of 1913. They are now dead. But all those who have endeavored to perpetuate this monstrous, immoral, criminal act of banking against the people and their posterity are in fact of law co-conspirators to the ongoing crime of backing and the international act of genocide against the white citizens in the several states of this American Union and their posterity. The following quote is taken from Bouvier's Law Dictionary 1856. Adhering, cleaving to, or joining, as adhering to the enemies of the United States. 1. The Constitution of the United States Article 3, Section 3 defines treason against the United States to consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. 2. The fact that a citizen is cruising in an enemy ship with a design to capture or destroy American ships would be adhering to the enemies of the United States. 4 State, Track 328. 3. If war be actually levied, that is, a body of men be actually assembled for the purpose of effecting by force a treasonable enterprise, all those who perform any part, act, or however remote from the scene of action, and those who are leagued in the general conspiracy are to be considered as traitors. 4 Cranch 126. So, has an act or acts of war or treason occurred within the jurisdiction of the executive authority of any one of the states or the United States of America? Powers granted or prohibited. Article 10. In addition to an amendment of the Constitution of the United States of America, 1791, quote, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. For those of you who are unfamiliar with the law of the flag, the next time you see a state of federal flag with gold fringe, be informed that the law of the gold fringe is admiralty, not the American common law. Admiralty equals martial law, no standing army. First act of war or treason. Hence, most of the common law courts fly this gold fringe admiralty flag, which is an act of war against the sovereignty of the people. For Congress to coin gold and silver money and regulate its value, second act of war treason. In this case is the printing of the non-redeemable counterfeit notes by a privately controlled alien group, Federal Reserve, and confiscate, steal all the gold and silver from the people. Congress shall establish a uniform rule of naturalization throughout the United States. Third act of treason war. Congress was never vested with the power to naturalize or to alter the status of the elector of the most numerous branch of the state legislature or any member trustee of our state and or federal republic. The United States shall guarantee to every state in the Union a republican form of government. Fourth, act of war treason. To convert our federal republic to a democracy is in itself the highest crime that could be committed against the people and their sovereignty. The principle stated in 2 above would follow here, that a citizen or group of citizens or persons who are engaged in an immoral, constitutionally prohibited act such as banking, who engage in the act of printing and exchanging that fraudulently worded foreign paper for the people's lawful coin or their public and private property, are in fact cruising in an enemy's vessel called the bank with a specific design to ultimately destroy our American common law monetary system and our republican form of government, while at the same time exterminating the common law citizen of the state while confiscating their soil, all of which are acts adhering to the enemies of the United States of America and the sovereignty of the people. For clarification, the term common law is quoted in the California Civil Code, section 22.2, wherein it states that the common law of England, so long as it is not repugnant to or inconsistent with the Constitution of the United States or the Constitution or laws of this state, is the rule of decision in all the courts of this state. So, England is in Europe, and by Noah Webster's 1828 Dictionary of the English Language, is the land of the white face. This means that the white men and women who are citizens of this state are the true posterity and sovereignty of this nation and are the source of the American common law as descended from the English common law. From Magna Carta 1215. The enemy here is the bank, commonly known as and called the Federal Reserve, of which every officer, employee, elected, or appointed officials, both city and county, both state and federal, and most people throughout the states and territories are all on its payroll. The subject status of which I speak, although originally a creature of Africa, was by way of the erroneously enacted 13th, 14th, and 15th Amendments to the U.S. Constitution, was used as a vehicle to alter the lawful status of the white people and increase the growing presence of the prohibited banks throughout the several states. Although having its original foundation in the Second Naturalization Law, it was accelerated under the guise of the Civil Rights Act 1866. This subject status is commonly known as a statutory 14th American citizen of the United States. Madison in Federalist paper number 43 made the following observation. May it not happen in fine that the minority of citizens may become a majority of persons by the accession of alien residents of a causal concourse of adventurers, or of those whom the Constitution of the state has not admitted to the rights of suffrage. See Van Valkenburg v. Brown, 1872, citing Dred Scott v. Sanford. The personal body of these foreign alien residents were already among us. The Constitution identifies them in Article 1, Section 2, Paragraph 3 as 3/5 of all other persons. And by the words of the Supreme Court in Scott v. Stanford, 1856. And accordingly, a Negro of the African race was regarded by them as an article of property and held and bought and sold as such in every one of the 13 colonies which united in the Declaration of Independence and afterwards formed the Constitution of the United States. This subject status of person by legislative act of Congress became the vehicle to enslave all the people by the phrase citizens of the United States, who are, by the wording in the 14th Amendment, are subject to its jurisdiction, District of Columbia, a municipal corporation. Remember, any act of Congress not citing a specific delegation of authority from the Constitution must be construed to have relied on the only two provisions giving it unlimited delegated power over a specific kind of soil for the express purpose of protecting the white people and their constitution. These two provisions are found exclusively in Article 1, Section 8, and Article 4, Section 3, of which neither was ever cited as its authority to create the Act of April 9, 1866, entitled Civil Rights Bill. The Civil Rights Bill of 1866. This act, which was, by its enforcement within the states, another void law in violation and repugnant to the American common law and the intent of the founding Federalist Fathers. For further definition of lowercase citizen of the United States, see Chapter 2, The People. A conspiracy or plot is identified as a combination of men for an evil purpose, an agreement between two or more persons to commit some crime in consort, particularly a combination to commit treason or excite sedition of insurrection against the government of a state, a plot as a conspiracy against the life of a king, a conspiracy against the government. Noah Webster. It might be well to examine the use and history of the word civil as it was used in all the writings of law, from the Magna Carta to the present day Constitution, to discover the hundreds of times this word was used, but only for the specific purpose to distinguish matters of a criminal nature from that of law, equity, admiralty, and maritime. A civil code combining law and equity found no place in the states or the United States until the years following the Civil War. But, as stated, law and equity were still isolated principles, except in a few states like Texas, where the Supreme Court admonishes it for combining law and equity under a civil code. This is what the framers of the Seventh Amendment had in mind. By the common law, they meant what the Constitution denominated in the third article law, not merely suits which the common law recognized among its old and settled proceedings, but suits in which legal rights were to be ascertained and determined, in contradistinction to those where equitable rights alone were recognized and equitable remedies administered. Fenn v. Home, 21. In Texas, the common law has been adopted, but the forms and rules of pleading in common law cases have not. And although the forms of proceedings and practice in the state courts have been adopted in the District Court of the United States, yet such adoption must not be understood as confounding the principles of law and equity, nor as authorizing legal and equitable claims to be blended together in one suit. Bennett v. Butterworth, 1850. And further, it is settled that the law of this state includes the common law as well as the Constitution and the codes. Code of Civil Procedures, 1895. Victory Oil Company v. Hancock Oil Company, 1954. Page blah blah blah. The code establishes the law of this state respecting the subjects to which it relates, but this does not mean that there is no law with respect to such subjects except that embodied in the code. Where the code is silent, the common law governs. Where the code is silent, the common law governs. Rojo versus Kliger. That's 1990. This is verification of the principle that was laid down by the revolution that birthed the true nature of the American common law, which is the act of doing whatever does not infringe upon the rights of the public at large or your neighbor. In order to exercise the American common law, do not engage the public at large by posting a sign of your calling or advertising this calling in any public way, whether by paper, posting, post, sign, advertising, notice, phone, dictionary, business card, internet, or running your private common law calling through the bank. To do otherwise is to open your private doors to the public at large and its commercial codes, rules, regulations, orders, licenses, taxes, and whatever else the government wants or can think of making you do. The Constitution is based on immutable principles, constitutions, errors of monarchies, religious edicts, Bibles, and untold numbers of other writings by so-called morally advanced wise men throughout history. Its founders have compiled the best of the best to ensure and secure that the American common law under God and their moral intent would be maintained by and for the white people and their posterity of we the white people. Which brings us to the next question of law. What specific article, section, and or clause of the Constitution of the United States of America in 1788 was cited by Congress authorizing it to enact the Federal Reserve Act in 1913? As previously cited, the law, Article 10 of Amendment states, the power not delegated to the United States by the Constitution, not prohibited by it to the states, are reserved to the states respectively, or the people. So what act of law authorized banking to become part of this state's minority system? Monetary system. So what act of law authorized banking to become part of this state's monetary system? Not only can none be found, but the Constitution of the United States of America, 1788, in Article 1, Section 10, Clause 1, states that no state, including but not limited to California, shall coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts. And it is further stated in the Act of Statehood for the California State Republic Constitution 1849, Article 4, Sections 34 and 35, Section 34. The legislature shall have no power to pass any act granting any charter for banking purposes. But associations may be formed under general laws for the deposit of gold and silver. But no such association shall make, issue, or put into circulation any bill, check, ticket, certificate, promissory note, or other paper, or the paper of any bank to circulate as money. Section 35. The legislature of this state shall prohibit by law any person or persons, association, company, or corporation from exercising the privileges of banking or creating paper to circulate as money when the money changers caused our common law California Constitution to be voided by the 1879 fraudulent replacement, leaving out the prohibition on banking. The words "no banking" was displaced by carefully fraudulently worded insertions like Section 5. The legislature shall have no power to pass any act, to pass any charter for banking purposes, but may be formed under general laws, blah, 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 for the purpose of regulating the business of banking. No corporation, association, or individual shall issue or put in circulation as money anything but the lawful money of the United States. California Constitution 1879, Article 13, amendment adopted by fraudulent U.S. voters November 8, 1910, under the Federal Reserve Act of 1913, and lawful money of the United States District of Columbia, commonly known as a Federal Reserve Note. The elector status was eliminated by the U.S. Congress with the so-called 15th Amendment. So just what is banking? The principal aim of banking is, and always has been, to turn non-redeemable fiat paper currency into gold and silver. It's much easier than turning lead into gold, because all you need is a thief, a bunch of gold and silver enriched in ignorant people, some ink, paper, and a printing press, and last but not least, a bank, historically known as a money changer. Legal or lawful? When does legal tender paper, as found on a private Federal Reserve note, become federal lawful money as identified in the Constitution as gold and silver coin? It doesn't, because the Federal Reserve is private and is not found anywhere in the Constitution over any one of the several states of their people. But if that paper was issued by act of Congress as applied to the states, it would say in the first line of the paper, United States note, and would then follow as redeemable, and only when that paper is redeemable in the real constitutionally struck under the power of Article 1, Section 8 by the U.S. Mint as in certified gold and silver coin, and not otherwise. First, find a system where the people have a gold and silver monetary standard. The United States of America and a bunch of ignorant people who don't understand the American common law. Second, wait until most of the founding fathers are dead and convince one of the remaining to help set up a bank in the District of Columbia, where there is no prohibitions against banking. Or better yet, in the state next door, like Maryland. That way, the building is the property of DC. Article 1, Section 8. What goes on there is no business of the state or any of them. Third, let the printing press roll, and don't forget to use the word federal on the note, so all the ignorant people will think it's a government issue. Time goes by and more ignorant people become used to the idea of paper, gold, and silver. One day in 1913, the Federal Reserve is born, and its bank starts printing gold certificates numbered from 100 to 100,000 US dollar denominations. Fourth, as all that is needed now is to trade them or sell them to the ignorant people for their gold at face value. You know, like a 1 troy ounce gold double eagle for a $20 Federal Reserve note problem. A little bit of propaganda goes a long way, and it's not long before most of the gold is in their hands. You guessed it, the bankers. Still, no problem. Paper gold running like water. All is well, except the bankers forgot to turn off the printing press. Well, what did they do with the extra double, triple amount of gold notes? I know. Let's give, loan, sell, whatever, them to some relative across the pond. Fifth, now the fun begins. Those relatives turn right around and exchange those extra notes for all the gold. Still no problem until one of the ignorant people decides to turn in all his paper gold to discover all his real gold is gone. Is this lawful? No, but it's profitable. Oops, bank run. Now you can see a really lot of depressed, ignorant people, some of which actually jumped out of their own real buildings. Real Depression in 1929. What a mess. So, is the Federal Reserve a moral person? Does its codes, rules, and paper conform to a moral standard? If the bank maintained a full redemption for all the notes printed and in circulation, it might be legal in some other country, but is not lawful as any other common law calling in our Republican form of government. But it doesn't, which is why it's prohibited by law in this state. And even though it has managed to infiltrate our monetary system, it still only operates under the commercial code that requires a license for it to exist. That code only applies to DC and its territories, not a state. Enter the law of license. Latin, licere, to permit. I permit you. In real property law, a permission, a right given by some competent authority to do an act, which without such authority would be illegal, or a tort or trespass. When the power of license is exercised by municipal corporations, such as a state, a license is the requirement by the municipality of the payment of a certain sum by a person for the privilege of pursuing his profession or calling. Taxi driver, for example. Bouvier's 1914 at page 1976. But only when said calling is with the public at large. A secure private right or calling is lawfully exempt from any of the state or federal national government. In Hale vs. Henkel, 1906, the court emphasized the rights of the citizen of the state to wit. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation as far as it may tend to criminate him. He owes no such duty to the state beyond the protection of his life and property. His rights are such as existed by the law of the land antecedent by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of law. He owes nothing to the public so long as he does not trespass upon their rights. They have converted the unalienable rights to liberty by the people to travel upon their public right of way and to transport his private property or private persons thereon into a licensable, taxable, insurable, criminally punishable commercial privilege of operating a motor vehicle subject to a motor vehicle code designed for the specific purpose to regulate the commercial act of transporting persons and or property for hire, profit, or gain with the general public. Stork, 1925, Exemption 18 USC, Section 32. That will conclude it for today, everybody. That is chapter 1, right? And that's saying a mouthful, to say the least. And I am personally going to be going over this document here and refining it. And I see places where it could be simplified. And I trust that you will get something out of listening and reading this document along with me. Good afternoon.